There was a case of a doctor which came to me, an allegation done by the assistant of a doctor for rape. I got a bail of that doctor during trial court. While reading the charge sheet, it was found that there is a high chances that rape has happened. But at the same time, there was opportunity for me and my team to prove that there could be a consensual part. And the third opportunity, what we could able to trace out in that this is a false case. And while trial in the court, we have tried to bring all the evidences with all the three aspects, because there is already honorable court judgment which said that crime should be proven 100%. We have tried to bring all the witnesses to the cross, which indicates that it could be a false case with malified intention. We have again brought the some witnesses on record, which show that even if it is consensual. The consent of both the parties were there. And third, the allegation done by the prosecution of a rape. Now, all the three proposition with all the three proofs was available in front of a judge, and the judgment of a Supreme Court, which is a precedent which need to be followed, was again in front of a judge. Ultimately, what happened? Since it was not beyond reasonable doubt proven, there was a confusion got created in the mind of the court. If there could be possibility of the consensuality, there could be possibilities of false allegation. There is also a possibility of rape, but there was no concrete thing which got proven against my doctor. And my doctor got acquitted in rape case. So Evidence Act plays a very vital role. We will understand that also in the series. What is the primary evidence? Where we talk about secondary evidence as an original document. Because 10 years later, my doctor will be called in a police station for the witness and no records are available. And then he need to depose in front of the court on the basis of the Xerox papers, which is challengeable, photocopy papers, which is challengeable in the court of. When what is going to help my doctor? We are going to learn in this series of criminal liability. Criminal liability is one of the place which is most important place in a medical practice. You randomly ask any of your friend and doctor what make him more stressful. He will definitely say to the police summon, police call, police interference, because fear is of a jail punishment in the mind of a dog. Being a high reputed person, being a white collar, even if he called to the police station, made them sit there for hour, he'd get disturbed. His practice get disturbed. But truly speaking, my friend, go to whole country, try to find out how many doctors got convicted, and if convicted under what law, under what section, and for what purpose. You will not find any of doctor got convicted for the treatment per se under 304A if it is presented well by the good advocates. If you admit in a court of law through your advocate, then you give evidence to the court. The presentation plays a vital role in our country. That's the reason why top criminal lawyers are needed in this country to protect the people, and people pay huge amount. There again, the knowledge comes in the picture. Criminal liability is a very, very important topic, friend. The second thing which I always recommend to every medical legal student here or a future medical legal consultant, you need to be expert in this. Because if you can save your doctor from this agony, he will never forget you. And he become a great advertiser for you to stabilize your medical law practice. He become real advertiser. I'll give an example to make you understand. Almost 8, 10 years back, I got a call from a doctor. In that case, he admitted a patient for poison. Stomach was done. Patient was absolutely fine. MLC was not done by this doctor. We are going to learn about MLC in IPC also. MLC was not done. RMO also forget to do MLC. Patient collapsed at evening 6 p.m. Knowing that he has not done MLC, he got worried. He called the police and given a body for the postmortem. At the same time, he called some of his friend. I said theoretical medical legal lawyer. He guided to contact the advocate. He contacted the advocate. You can't expect the advocate will know everything. He has bide the time. He said, you leave the place for 2 days, send me papers and ₹1,00,000. Tomorrow I'll file an anticipatory bail for you. My doctor feared with the jail punishment, send ₹1,00,000 to this particular advocate and all the papers and left territory. Next day morning, naturally, he is going to contact many people in worry point. He reached to me. Since I am continuously on this particular field, I was aware about MNCs and its impact. I called back this doctor to the hospital. I said, not to worry. Because even if at all punishment is being given, I'm talking about worst scenario, which is 1% chance, not 99% is not going to happen. Let no police take a cognizance of that. I said, even if at all there is any mean of police station, you have been put under this. And in trial court, it is proven, then also the penalty is 1 month jail or ₹1,000 fine. And when our word comes, being a doctor, being a white collar people, being a people who are needed to society, we get a benefit of our in majority of cases. What could maximum would have happened is ₹1,000 fine after 8, 10 years of the trial. But he has already spent ₹1,00,000 in one day hospital loss of hospital practice. But since we discussed, we could able to understand the law together. He came back and today, even after 10 years, he still talks about the case. Many of the people and to me and not ready to leave. That is what is the strength of a criminal liability. If you can protect your client from criminal liability, believe me, my friend, you can be a good medical legal lawyer in this country. You can be top consultant in this country. You can really make a difference in the life of the people.